Now, the first question which was posed relates to a much bigger issue than just sexual assault, but it relates to a question I raised in class, or a discussion that we had about the evidentiary burden. And the evidentiary burden, as you may remember, is a really significant part of of criminal law. And the evidentiary burden comes into play for a number of reasons. First of all, remember that the evidentiary burden is designed to simplify trials. And what it reminds us is that although the burden of proof is always on the Crown to prove matters beyond a reasonable doubt, that doesn't mean that the Crown has to prove any possible thing that can be speculated upon by a clever defense lawyer in a case. Essentially, what it means is, before a matter can be put to the jury, there must be some evidence. And what I mean by some evidence is a pretty low threshold. Just some evidence that is capable, that if it was believed, it could lead a jury to have a reasonable doubt about a particular defense or an absence of an element of the offense. And we looked at the evidentiary burden in the context of sexual assault. And in particular, the context we looked at it was the issue of in situations where, there's a story by the complainant, and then there's the story by the accused, and they go head to head. And the issue is, she's saying no consent, and he's saying consent, and the courts have argued that there's no room for the defense of honest mistaken belief in consent. Okay, and that was the basis in which we looked at. Now, the only thing I want to focus on, I don't want to go through the entire evidentiary burden again, but I want to just clarify a few aspects of what the evidentiary burden means. I don't want you to confuse, in particular, two things. One is who bears this burden, but the second is where this burden, where evidence to satisfy this burden comes from. The accused bears the burden of showing that, for example, honest mistaken belief is available. In other words, the accused must be able to point to some evidence to show that there is a reasonable case. And don't confuse that with an objective standard, but there is a case that could go to the jury on honest mistaken belief. And as we saw in Esau, there was some evidence. It wasn't an overwhelming amount of evidence, but there was some evidence, if the jury believed the accused story, that would suggest that he could have an honest mistaken belief in the circumstances. At least that's what the majority said. But here's the thing I want you to keep in mind. Where does that evidence come from? Don't think that the where is connected to who bears the burden. That's not true. The evidentiary burden, as you will see as we go into defenses later on in this course, can be satisfied in any circumstance where the accused can point to any evidence that supports their particular defense. Therefore, that may well come and will usually come when the accused testifies. But even if the accused does not testify, they can still raise defenses and they can still say, I had an honest mistaken belief in consent. So long as there is any evidence that has been put before the trial that is capable of supporting that particular defense. So again, don't confuse the fact that the accused has the evidentiary burden to point to some evidence and the fact that the accused has to raise that evidence, because that's not true. The evidence can come from anywhere, and many times it will. If the evidentiary burden, as I suggested to you, is also available in other circumstances, so let's say, for example, there's a fight, and the guy comes forward. I'll just give you a good example of this. So the Crown calls a witness, and they say that, the Crown witness is, he started it. It was all him. He started the fight. Okay? But the accused wants to plead self-defense, but doesn't want to testify. Don't worry about why. Doesn't testify. Now, when you look at the evidence of this witness, there's no real evidence of self-defense. Nothing at all. But there might be another witness. And that other witness might come forward and said, you know what? I saw this guy, the accused, and I think he started the fight. But I also heard this guy over here say something, and I'm not exactly sure what it was. It may have been a threat. Now, obviously I'm exaggerating for the purposes of effect, but essentially this is an eyewitness, and this eyewitness is called by the Crown. And this eyewitness may provide enough hints of a self-defense case, that the self-defense case has to go to the jury. And the jury has to accept whether or not the Crown has proven that the accused started the assault beyond a reasonable doubt and was not defending themselves. And that really is a question for the jury, as long as there is any evidence to support the evidentiary burden. So don't confuse evidentiary burden and a burden to adduce evidence, because that's not true. There is no burden on the accused to call evidence as long as there's some available from any witness in the case.